Greetings, Wyoming. I'm Jason Moyer, the State Equal Employment Manager for the Wyoming Military Department. The EEO Department serves the entire federal staff of the Wyoming Military Department, whether it's inquiry into workplace conflict, alleged unlawful discrimination, reasonable accommodation, EEO training, or alternative dispute resolution. We are here to serve you. I'd like to personally congratulate you on your selection and welcome you to the agency. Some key points I'd like to point out is our zero tolerance areas in EEO. Sexual harassment, workplace violence or harassment, bullying, racial epithets, racial and gender stereotyping, or any other form of unlawful discrimination. The entire command team is committed to addressing any allegation in these areas. Sexual harassment can be manifested in 4 ways. It can be oral, visual, written, or physical. In today's environment, it can also have multiple communication methods to include electronic. Harassment is a form of employment discrimination that violates Title VII of the Civil Rights Act of 1964. It can fall in the place of workplace harassment or sexual harassment. Workplace harassment is defined as unwelcome, repeated behavior that targets, belittles, or threatens an individual or group of workers based on their sex, race, religion, or other protected statuses. It can create a hostile work environment and a risk to health and safety. It can be verbal or physical and may come from a supervisor, coworker, or non-employee. Sexual harassment is unwelcome conduct of a sexual nature. It includes unwelcome sexual advances, requests for sexual favors, and other verbal, nonverbal, or physical conduct of a sexual nature. Sex-based discrimination can happen to people of any sex and be perpetrated by people of any sex. Sexual harassment comes in 2 separate forms. The first being quid pro quo, which occurs when employment decisions such as hiring, promotions, salary increases, work assignments, and such are contingent on an individual's willingness to grant or deny sexual favors. The second is a hostile work environment, which is an unwelcome harassment is severe or pervasive enough to alter the working environment or create an abusive, intimidating, or offensive work environment. Generally, a single or isolated incident is not enough to create a hostile work environment. However, a single, unusually severe incident may be enough, particularly if the incident is physical. Individuals who feel they've been harassed should take action immediately and inform the person they feel has been harassing them that the behavior is unwelcome, unacceptable, and must stop. Also, report the harassing conduct to their immediate supervisor. Any harassment that is non-discriminatory in nature should be reported to the Labor and Employee Relations Office. Federal regulation requires any individual who believes they have been a victim of discrimination based on a protected category must make contact with the EEO office within 45 days of the date of the alleged discriminatory event or 45 days of becoming aware of the event. Informal EEO complaints submitted after the 45-day timeline may be dismissed due to untimely filing. For issues not discriminatory in nature, individuals are encouraged to contact their supervisor, the Inspector General's office, or seek assistance from the Labor Relations Office. There are 2 stages in the complaint process, formal and informal. Complaints start in the informal stage. This gives the agency the opportunity to perform a limited inquiry into the allegations made and attempt to resolve the issue at the lowest level. Individuals also have the option to elect the Alternative Dispute Resolution Process, or ADR, to resolve their issue. ADR is a form of mediation when an independent third party helps facilitate communication between the parties to come up with a mutually acceptable resolution. If ADR is selected, the process time is automatically extended to 90 days. This allows for flexibility in meeting selection and gives both parties time to prepare for the mediation. If the issue cannot be resolved, a notice of final interview with a notice of right to file formal letter will be provided. This completes the informal process. An individual will have 15 days after receiving the right of file formal letter to file a formal complaint. As a reminder, for the timeframes of filing, for the informal complaint process, you must contact the EEO office within 45 days of the discriminatory event or 45 days of becoming aware of the event. Now let's talk about the laws that are the foundation of the Equal Opportunity Program. In 2002, the government passed the Notification and Federal Employee Anti-Discrimination and Retaliation Act of 2002, more commonly known as the No Fear Act. This act had 3 titles, the first being General Provisions, which allows agencies to take disciplinary action against those who violate anti-discrimination laws. The second, the Federal Employee Discrimination and Retaliation Title II, requires repayment and reimbursement from the agency any costs back to the Treasury associated with findings against the agency. And Title III, EEO Complaint Data Disclosure Title, requires the agency to post EEO complaint data on their website. Now, reviewing the core laws of the EEO program, we will go over them now. The first being the Civil Rights Act of 1964, which prohibits employment discrimination based on race, color, national origin, religion, and sex, which includes pregnancy, gender identity, and sexual orientation, as well as bullying. The Age Discrimination in Employment Act of 1967 forbids age discrimination amongst people who are age 40 or older. This law does not protect workers who are under 40 and establishes federal employees may not be mandated to retire due to age. The Pregnancy Discrimination Act of 1978 prohibits discrimination against employees based on pregnancy, childbirth, or related medical issues due to pregnancy, such as leave, insurance programs, and so forth. The Equal Pay Act of 1963 abolishes wage disparity based on sex when the job involves similar skills, effort, and responsibilities. The Rehabilitation Act of 1973 requires affirmative action in employment by the federal government and by government contractors and prohibits discrimination on the basis of disability in programs conducted by federal agencies and programs receiving federal finance assistance in federal employment and in employment practices of federal contractors. The standard for determining employment discrimination under the Rehabilitation Act are the same as those used in Title I of the Americans with Disability Act. An individual with a disability is someone with a physical or mental impairment that substantially limits one or more major life activities and has a record of such impairment or is regarded as having such an impairment. Qualified means the individual satisfies the job-related requirements for the position they hold or are applying for and can perform the essential functions with or without reasonable accommodation. The following are some examples of unfair employment acts, which include appointments, performance evaluations, awards, discriminatory harassment, promotions, and so forth. Remember, harassment as the EEO claim must be based on a protected class covered in the anti-harassment laws. Federal agencies are required to maintain a reasonable accommodations program. Supervisors will make every effort to provide requesting employees with reasonable accommodation in order to perform the essential functions of his or her duties. Not every accommodation may be considered reasonable. The Reasonable Accommodation Coordinator will assist in determining if a reasonable accommodation is in order. Reasonable accommodation decisions will be determined within 30 calendar days of the request. And that concludes our EEO brief. My name is Jason Moyer, and above is my contact information. Please feel free to contact me if any issues or questions or concerns. Thank you, and welcome to the agency.